In high-stakes litigation, the battle for truth is fought through the careful management of documents, what is disclosed, what is protected, and how the process is balanced. The Sterling and Wellington scenario dramatizes these challenges, but the underlying legal concepts are universal. Understanding these 16 key terms is essential for lawyers, paralegals, law students, and compliance officers everywhere. Standard disclosure is a foundational concept in litigation, but its scope and application vary significantly between common law and civil law systems. In common law jurisdictions such as the UK, US, Canada, and Australia, standard disclosure generally requires parties to identify and disclose all documents relevant to the issues in dispute, including those that support or undermine either side's case. The UK mandates a comprehensive list of all relevant documents, while the US adopts a broad discovery process encompassing all relevant, non-privileged information. Canada typically requires an affidavit listing all pertinent documents, and Australia's approach varies by court, but often involves mandatory or court-ordered disclosure. In contrast, the EU civil law system takes a more restrictive stance. Standard disclosure is limited, usually court-ordered, and often reserved for specific contexts such as competition law cases. This reflects a fundamental difference. Common law systems emphasize broad, party-driven disclosure to ensure transparency and fairness, whereas civil law systems prioritize privacy and judicial control, limiting disclosure to what is strictly necessary for the resolution of the dispute. In the context of litigation, specific disclosure refers to a targeted process where a court orders the production of particular documents that are not covered by standard disclosure. In the UK, this mechanism allows a party to request the court to compel the other side to disclose specific documents if there is a good reason to believe they exist and are relevant to the case. Similarly, in the US, a party dissatisfied with the opposing party's disclosure can file a motion to compel, asking the court to order the production of specific documents or information that have not been voluntarily disclosed. In Canada and Australia, courts can also issue orders for specific disclosure, often in response to a party's application identifying particular documents or categories that are crucial to resolving the dispute. In the EU's civil law system, specific disclosure is even more narrowly tailored and typically only granted by the court in exceptional circumstances, such as competition law cases, where the necessity for particular documents is clearly demonstrated. This approach reflects the broader distinction between common law's more flexible, party-driven discovery and civil law's preference for judicial control and minimal disclosure. Inspection rights in litigation. A comparative overview. Inspection is a crucial phase in litigation, granting parties the opportunity to examine documents and evidence held by the opposing side. In most common law jurisdictions, such as the UK, US, Canada, and Australia, parties typically have a broad right to inspect documents disclosed by the other party, unless those documents are protected by legal privilege, ensuring the process is transparent and fair. In the US, this right extends even further to include not only physical documents, but also the ability to inspect, copy, and test electronically stored information, ESI, reflecting the modern realities of digital evidence. Canada and Australia uphold similar rights, allowing inspection unless a privilege is specifically claimed. In sharp contrast, the EU's civil law system restricts inspection to situations where the court expressly grants permission, making inspection a rarer, more tightly controlled procedure. This divergence highlights the fundamental difference between common law's emphasis on open, party-driven discovery and civil law's focus on judicial control and limited access, ensuring that only the most relevant and necessary materials are brought forward in court. Ultimately, the right to inspect plays a pivotal role in ensuring that justice is not only done, but seen to be done, balancing transparency with the protection of confidential or privileged information. The table outlines how three key legal terms, standard disclosure, specific disclosure, and inspection, are defined and applied in 5 major jurisdictions: UK, common law; US, common law; EU, civil law; Canada, common law; and Australia, common law.